Welcome to EUPrivacyForAll Session50 on GDPR, Joint Operations of Supervisory Authorities, Article 56. European Parliament suggested the deletion of most provisions of Article 56. Only paragraph 2 remaining would have been stating that the lead supervisory authority, as defined in Article 54a, shall involve the supervisory authority of each of those member states to take part in the respective joint investigative tasks or joint operations. Most of all, a provision was added stressing that the lead authority shall act as a single contact point for the controller or the processor. It was not laid down in the final version of Article 56. Along with other modifications, European Council suggested the addition of 3 provisions. One on the staff of a seconding supervisory authority operating in another member state and the liability involved for the member state of the host supervisory authority. Also, the fact that any damage caused by the staff of one authority on the territory of another member state shall be reimbursed, and the principle according to which each member state shall refrain from requesting reimbursement of damages. In the final draft of Article 56, it is stressed that joint operations include joint investigations but also joint enforcement measures. The obligation made to each supervisory authority to conduct joint operations also specifies that the controller or processor having establishments in several member states or where a significant number of data subjects in different member states are likely to be substantially affected would entail that the supervisory authority of each of those member states shall have the right to participate in the joint operations. It is stressed that the competent supervisory authority and not the lead supervisory authority shall invite other DPAs of those member states to take part in the joint operations and respond without delay to the requests of any supervisory authority wishing to participate. The following provision of Article 56 mainly frame and determine the way this joint operation mechanism would work. So, for instance, a supervisory authority may confer powers, including investigative powers, on the seconding supervisory authorities members or staff involved in joint operations. Or the staff of a seconding supervisory authority operating in another member state would entail that a member state of the host supervisory authority will assume responsibility of their actions. Moreover, the member state of the seconding supervisory authority whose staff has caused damage to any person in the territory of another member state shall reimburse. Each member state shall refrain, as stressed by EU Council, to request reimbursement of damages. And where a joint operation is intended and a supervisory authority does not comply within 1 month, each DPA may adopt a provisional measure on the territory of its member state. The key recital is 104, stressing that each supervisory authority should participate in joint operations and that the requested supervisory authority should be obliged to respond in a defined time period. Recital 109 also makes clear that joint operations may be carried out between the concerned supervisory authority and a bilateral or multilateral basis without triggering the consistency mechanism. As with regards to mutual assistance, other key provisions would be Article 54A1A on the cooperation between the lead and other supervisory authorities, and Article 58.2 on the opinion of the EDPB being requested in cases in particular where a competent supervisory authority does not comply with its obligation. Currently, the directive does not have any provision framing specifically joint operations, but just a general principle laid down in paragraph 6 of Article 28. What should accountable data controllers and processors get prepared for? They should first identify the lead and any other concerned DPA, but in the frame of joint operations, specifically identify whether a DPA is competent to trigger joint operations. The lead might request at any time assistance from any other DPA for joint operations. That might include joint investigations and joint enforcement measures. It was not let down in the final draft of GDPR, as suggested by European Parliament, that the lead DPA would act as a single contact point for the processor or controller concerned. A competent DPA might confer powers, including investigative ones, on the seconding supervisory authorities members or staff. Each DPA may also adopt a provisional measure on the territory of its member state. EDPB will be the one consulted on all issues resulting from the implementation of joint operations. The key question we might have in mind today is knowing whether joint operations will become the standard process to enforce EU data protection rules consistently in EU, and in such a case, how should controller and processors exchange with the lead DPA, the competent DPA triggering the joint operation, and any other concerned DPA?